Ramos v. CA. Facts: on April 18, 1990, petitioners filed a petition before the Court a quo for the declaration of nullity of Municipal Ordinances No. 91 and No. 7 and the contract of lease over a commercial arcade to be constructed in the municipality of Bailey Uok, Bulacan. Meanwhile, the provincial fiscal and the provincial attorney, Oliviano D. Regalado, filed an answer on behalf of respondent municipality. At the pre-trial conference, attorney Roberto B. Romanillos appeared, manifesting that he was counsel for the municipality. On the same date, attorney Romanillos filed a motion to dissolve injunction and a motion to admit an amended answer with motion to dismiss. The provincial attorney appeared as collaborating counsel of attorney Romanillos. The provincial fiscal did not appear. It was attorney Romanillos who submitted the reply to petitioners' opposition to respondents' motion to dissolve injunction. It was also attorney Romanillos who submitted a written formal offer of evidence for the municipality. Despite the hearing, petitioners questioned the personality of attorney Romanillos to appear as counsel of the municipality. Meanwhile, attorney Romanillos and attorney Regalado filed a joint stating that attorney Romanillos was withdrawing as counsel for respondent municipality and that attorney Regalado, as his collaborating counsel for respondent municipality, is adopting the entire proceedings participated in / undertaken by attorney Romanillos. The judge denied the petitioner's motion to disqualify. Issue: who is authorized to represent a municipality in its lawsuits? Ratio: in the recent case of Municipality of Paililla, Rizal vs. CA, this court, through Mr. Justice Florence D. Regalado, set in clear-cut terms the answer to the question of who may legally represent a municipality in a suit for or against it. Thus, the matter of representation of a municipality by a private attorney has been settled in Ramos vs. CA, ETL, and reiterated in Province of Cebu vs. IAC, ETL, where we ruled that private attorneys cannot represent a province or municipality in lawsuits. Section 1683 of the Revised Administrative Code provides. Sector 1683. Duty of fiscal to represent provinces and provincial subdivisions in litigation. The provincial fiscal shall represent the province and any municipality or municipal district thereof in any court, except in cases whereof original jurisdiction is vested in the Supreme Court or in cases where the municipality or municipal district in question is a party adverse to the provincial government or to some other municipality or municipal district in the same province. When the interests of a provincial government and of any political division thereof are opposed, the provincial fiscal shall act on behalf of the province. When the provincial fiscal is disqualified to serve any municipality or other political subdivision of a province, a special attorney may be employed by its council. Under the above provision, complemented by Section 3, RA 2264, the Local Autonomy Law, only provincial fiscal and the municipal attorney can represent a province or municipality in their lawsuits. The provision is mandatory. The municipality's authority to employ a private lawyer is expressly limited only to situations where the provincial fiscal is disqualified to represent it. For the aforementioned exception to apply, the fact that the provincial fiscal was disqualified to handle the municipality's case must appear on record. In the instant case, there is nothing in the records to show that the provincial fiscal is disqualified to act as counsel for the municipality of Paililla on appeal, hence the appearance of herein private counsel is without authority of law. The provincial fiscal's functions as legal officer and advisor for the civil cases of a province and corollarily, of the municipalities thereof, were subsequently transferred to the provincial attorney. The foregoing provisions of law and jurisprudence show that only the provincial fiscal, provincial attorney, and municipal attorney should represent a municipality in its lawsuits. Only in exceptional instances may a private attorney be hired by a municipality to represent it in lawsuits. These exceptions are enumerated in the case of Alinsig vs. RDC BR 58, San Carlos City, Negros Occidental, to wit. Indeed, it appears that the law allows a private counsel to be hired by a municipality only when the municipality is an adverse party in a case involving the provincial government or another municipality or city within the province. This provision has its apparent origin in the ruling in Digia v. the Auditor General, where the court held that the municipality's authority to employ a private attorney is expressly limited only to situations where the provincial fiscal would be disqualified to serve and represent it. With Sector 1683 of the Old Administrative Code as legal basis, the court therein cited Enriquez, Sr. v. Jimenez, which enumerated instances when the provincial fiscal is disqualified to represent in court a particular municipality, if and when original jurisdiction of case involving the municipality is vested in the Supreme Court, when the municipality is a party adverse to the provincial government or to some other municipality in the same province, and when, in a case involving the municipality, he, or his wife, or child, is pecuniarily involved, as heir legatee, creditor, or otherwise. Thereafter, in Ramos vs. CA, the court ruled that a municipality may not be represented by a private law firm which had volunteered its services gratis, in collaboration with the municipal attorney and the fiscal, as such representations was violative of Sector 1683 of the Old Administrative Code. This strict coherence to the letter of the law appears to have been dictated by the fact that the municipality should not be burdened with expenses of hiring a private lawyer, and that the interests of the municipality would be best protected if a government lawyer handles its litigations. None of the foregoing exceptions is present in this case. It may be said that attorney Roman Illos appeared for respondent municipality inasmuch as he was already counsel of Christie Corporation, which was sued with respondent municipality in this same case. The order of the trial court dated September 19, 1990, stated that attorney Roman Illos entered his appearance as collaborating counsel of the provincial prosecutor and the provincial attorney. This collaboration is contrary to law and hence should not have been recognized as legal. It has already been ruled in this wise. The fact that the municipal attorney and the fiscal are supposed to collaborate with a private law firm does not legalize the latter's representation of the municipality of Hagonoy in civil case No. 5095M. While a private prosecutor is allowed in criminal cases, an analogous arrangement is not allowed in civil cases wherein a municipality is the plaintiff. As already stated, private lawyers may not represent municipalities on their own. Neither may they do so even in collaboration with authorized government lawyers. This is anchored on the principle that only accountable public officers may act for and in behalf of public entities, and that public funds should not be expanded to hire private lawyers. Petitioners cannot be held in estoppel for questioning the legality of the appearance of attorney Roman Illos, notwithstanding that they questioned the witnesses of respondent municipality during the hearing of its motion to dissolve the preliminary injunction. Municipality of Pilila, Resolve S. Court of Appeals held that the legality of the representation of an unauthorized counsel may be raised at any stage of the proceedings. Elementary fairness dictates that parties unaware of the unauthorized representation should not be held in estoppel just because they did not question on the spot the authority of the counsel for the municipality. The rule on appearances of a lawyers is that until the contrary is clearly shown, an attorney is presumed to be acting under authority of the litigant whom he purports to represent. His authority to appear for and represent petitioner in litigation, not having been questioned in the lower court, it will be presumed on appeal that counsel was properly authorized to file the complaint and appear for his client. Issue: would the adoption by attorney Regalado of the proceedings participated in by attorney Roman Illos validate such proceedings? Held yes. Ratio: it does not appear that the adoption of proceedings participated in or undertaken by attorney Roman Illos when he was private counsel for the respondent municipality of Bailey Uig, such as the proceedings on the motion to dissolve the injunction, wherein petitioners had even cross-examined the witnesses presented by attorney Roman Illos in support of said motion, and had even started to present their witnesses to sustain their objection to the motion, would have resulted in any substantial prejudice to petitioners' interest. As we see it, to declare the said proceedings null and void notwithstanding the formal adoption thereof by attorney Regalado as provincial attorney of Bulacan in court, and to require trial anew to cover the same subject matter, to hear the same witnesses and to admit the same evidence adduced by the same parties, cannot enhance the promotion of justice. This court believes that conferring legitimacy to the appearance of attorney Roman Illos would not cause substantial prejudice on petitioners. Requiring new trial on the mere legal technicality that the municipality was not represented by a legally authorized counsel would not serve the interest of justice. After all, this court does not see any injustice committed against petitioners by the adoptions of the work of private counsel, nor any interest of justice being served by requiring retrial of the case by the duly authorized legal representative of the town. In sum, although a municipality may not hire a private lawyer to represent it in litigations, in the interest of substantial justice, however, we hold that a municipality may adopt the work already performed in good faith by such private lawyer, which work is beneficial to it provided that no injustice it thereby heaped on the adverse party, and provided further that no compensation in any guise is paid therefor by said municipality to the private lawyer. Unless so expressly adopted, the private lawyer's work cannot bind the municipality. Issue 1 joint motion need not comply with Rule 15 held yes ratio. We also agree with the justification of public respondent that a motion to withdraw the appearance of an unauthorized lawyer is a non-adversarial motion that need not comply with Section 4 Rule 15 as to notice to the adverse party. The disqualification of attorney Roman Illos was what petitioners were really praying for when they questioned his authority to appear for the municipality. The disqualification was granted, thereby serving the relief prayed for by petitioners. Such being the case, no notice directed to the parties concerned and served at least 3 days before the hearing thereof 30 need be given petitioners, the questioned motion not being contentious. Besides, what petitioners were questioning as to lack of authority was remedied by the adoption of proceedings by an authorized counsel, attorney Regalado. The action of the trial court allowing the motion of respondent municipality effectively granted petitioners' motion to disqualify attorney Roman Illos. In People vs. Levist, we ruled that while it is true any motion that does not comply with the requirements of Rule 15 should not be accepted for filing and, if filed, is not entitled to judicial cognizance. This court has likewise held that where a rigid application of the rule will result in a manifest failure or miscarriage of justice, technicalities may be disregarded in order to resolve the case. Litigations should, as much as possible, be decided on the merits and not on technicalities. As this court held in Galvez vs. Court of Appeals, an order of the court granting the motion to dismiss despite the absence of a notice of hearing, or proof of service thereof, is merely an irregularity in the proceedings, which cannot deprive a competent court of jurisdiction over the case. It should be remembered that rules of procedure are but tools designed to facilitate the attainment of justice, such that when rigid application of the rules tend to frustrate rather than promote substantial justice, this court is empowered to suspend their operation.